Hello and welcome to the immigration webinar, an update on the latest UK immigration changes. My name is Ilda and I'm a partner at Kingsley Napoli in the immigration team with my colleagues Moji, Oyediran and Rizwana Quazi, both associates in the immigration team. Today we're going to give you an overview of the current changes that have taken place and that will take place in next year. My colleague Rizwana Quazi will also be talking about the Tier 2 general changes in more detail, whilst my colleague Moji Oyediran will be talking about the Tier 2 intra-company transfer changes as well as the changes affecting family members of points-based migrant workers, along with relevant changes. I will then finish off with future changes. So in terms of a general overview, the government announced changes to the Tier 2 intra-company transfer and Tier 2 general categories in March of 2016. These changes were actually following the recommendation from the Migration Advisory Committee during 2015. Now, essentially, these changes are going to be implemented in two stages. The first in the autumn of 2016, which are the changes that we'll be focusing on in more detail, and then the changes that will be announced then and due to take effect in April of 2017. Now, the latest statement of changes essentially covered just the first tranche of changes for the autumn of 2016, whilst the changes for April 2017 we won't necessarily cover in this webinar. Now, the changes that we'll talk about are really designed to have an impact on Tier 2 sponsors and are partly intended to focus on employer behaviour by incentivising businesses to rely less on migrant workers. With that, I'm going to hand over to my colleague Rizwana Quazi, who will talk to you about the Tier 2 general category.
So I'm going to start with the Tier 2 general changes and commence with changes to the salary thresholds. The salary threshold for experienced workers has now been increased to 25,000 from 20,800, with the new entrant salary threshold still being held at 20,800 or the appropriate rate as per the Standard Occupation Classification Code. There are exemptions for some occupations such as nurses, paramedics, secondary school teachers in certain subjects. However, the exemptions for them will end in July 2019. To give you further insight, the government also intends to increase the threshold further to 30,000 in April 2017. Transitional arrangements are in place that mean that the higher 25,000 threshold will not apply to Tier 2 general sponsored workers extending their stay in this category, i.e. those who were initially granted leave to enter or remain with a certificate of sponsorship assigned before 24th of November 2016. So continuing with the changes to salary thresholds, no such transitional arrangement will apply for workers sponsored in Tier 2 General between 24th of November 2016 and April 2017. They will need to satisfy the 30,000 threshold in any future application. So, for example, a creative director, currently an experienced worker, needs to satisfy the minimum salary threshold of 27,300. However, in the future, from April 2017, the minimum salary threshold they will need to satisfy is 30,000. There is further clarification on the prorating of salary figures. Rules now state that rates will always be prorated based on the numbers of working hours stated on the certificate of sponsorship. Previously, the rules indicated that the annual salary figure should be prorated only where a person has contracted weekly hours or is paid an hourly rate. Where the applicant is paid hourly, the appropriate salary consideration will be based on earnings up to a maximum of 48 hours per week, even if the applicant works longer than this. Applicants cannot benefit from the lower new entrant salary where the relevant criteria applies, but a job is on a shortage occupation list and requires the job holder to have a minimum level of experience. So to go on to graduates, there are a couple of changes here. So essentially the UK graduates who return overseas have been weighted more heavily in the monthly allocation rounds under the Tier 2 limit. Graduates who apply in the UK continue to be exempt from the limit, so these would be Tier 4 students essentially switching in country to the Tier 2 general category. A change is being made to facilitate changes of occupation for applicants sponsored in graduate training programs. So to give you a brief background about a graduate training program, this is essentially used to transfer recent graduate recruits to the UK for training for any period of up to a maximum of 12 months. This cannot be used to fill long-term posts. So essentially this change enables these graduates to change occupation within the program or at the end of the program without their sponsor needing to carry out a further resident labour market test or for them to make a new application. Essentially, this creates or provides more flexibility. Going on to Tier 4 students. Tier 4 students switching into Tier 2 General must have studied their course at a UK recognised body or a body in receipt of public funding as a higher education institution. They cannot rely on a qualification obtained through supplementary study. So, just to explain a bit further about supplementary study, this is where sponsored workers also decide to study in addition to their day-to-day job role, however ensuring that the study does not affect their employment, but essentially they study on the side to advance themselves further. So moving on to milk rounds. Milk rounds are essentially recruitment exercises where companies attend universities to recruit students. From April 2017, a change to the rules around advertising via a milk round will be introduced, where a sponsor can offer a job to a migrant 4 years after carrying out a milk round without the need for a further recruitment search. Now, the changes stipulate that sponsors can continue to rely on a milk round, which ended up to 4 years, but only providing the migrant was offered the job within 6 months of that milk round taking place. So to give you an example of dates really, if a milk round campaign started in April 2013, the sponsor needs to be able to demonstrate that the candidate was offered the job before October 2013. Now, this isn't always practical and viable, as it's common knowledge that essentially lots of firms, for example law firms, even recruit students many years, several years in advance. Moving on to nurses. Following a separate review by the Migration Advisory Committee on nursing shortages, nurses are being retained on the shortage occupation list, but a change is now being made to require resident labour market tests to have been carried out before a nurse is assigned a certificate of sponsorship. There is slight tightening now of the nursing occupation. The next point, continuing to work in the same occupation for the same sponsor. An additional requirement has been added to the requirements for those applying for further leave to remain in order to continue to work in the same occupation for the same sponsor. This is to confirm that the applicant must not be changing jobs within an occupation from a shortage occupation job to a non-shortage occupation job. If it transpires this is the case, then an RMT must be carried out. I'm now going to hand over to my colleague Moji, who will be taking you through further changes to the immigration rules.
Okay, so I'll be taking you through some of the changes that relate to the Tier 2 intra-company transfer category. There have been changes to the salary thresholds under this subcategory as well, and the minimum salary has now increased to 30,000 for all new applicants. Under the transitional arrangements, current applicants who are already in this route and applying for an extension won't have to meet the higher threshold. However, any new individuals you want to transfer to the UK under that category have to meet the minimum 30,000 salary going forward. The salary threshold for graduate trainee category is also changed. It has actually reduced from the previous level of 24,800 and will going forward now be 23,000. The number of places available for use under this subcategory has also been increased and now will be 20 per year instead of the previous level of 5, which makes it a bit easier for sponsors who use this subcategory. Importantly, a change to the skills transfer subcategory has occurred with effect from the 24th of November 2016. This route is now closed to all new applicants and can no longer be used going forward. If you have previously transferred individuals under this category for short-term training in the UK, you'll now need to look to apply for visas for them under the business visitor category, provided their activities will fit within the permitted activities here. CARS allocations under the Tier 2 has also changed in relation to the graduate trainee category. Sponsors can now assign up to 20 certificates of sponsorship as opposed to the 5 previously. Moving on now to changes affecting family members of points-based system migrants. Family members who, under the terms of their visa, are allowed to undertake studies in the UK while they're here, as for example a Tier 2 general partner. If they want to study certain subjects, they will now need to apply for academic technology approval under the Academic Technology Approval Scheme, ATAS, in order to be granted permission to undertake studies in the relevant subjects. This must be completed before they can start studying. One important change that we're still seeking clarification from, the Home Office, is that the new rules appear to introduce a new definition of continuous residence, and this is in relation to the absence requirements under the indefinite leave to remain application process. Currently, as far as the rules prior to these changes, the dependents don't have to provide any absences during the period of their visas in the UK. The new rules appear to indicate that they now, going forward, will have to provide the schedule of their absences. Once we have clarity, we will of course update you accordingly. Staying with family members of point-based systems migrants, the maintenance requirement is one which needs to be met in relation to an application, and the rules now clarify that where an employer, an A-rated sponsor, is certifying maintenance for the dependent, this can be done by way of a letter rather than on the COS. So this will be relevant where you have an individual who has had a child born to them in the UK, and the individual is making an application to bring the child in line and have the child granted a visa. The letter will need to confirm the details as stated in the slide there, the applicant's name, sponsor's name and logo, and details of any limits on the level of the undertaking provided. So moving on to other relevant changes generally, there is now a clarification in relation to the evidence required to satisfy the English language requirements. The degree certificates that are provided in support of an application to confirm English it's been studied at the correct level now no longer need to show that the degree was taught in English. Instead, the Home Office will expect the individual applicant to have obtained an original document from UK NARIC, which is the organisation that assesses qualifications undertaken overseas and confirms effectively that the level of the qualification is in line with a UK bachelor's degree or master's or PhD. And going forward, that confirmation will now also confirm that it was taught or researched in English to either the A1 or the A2 standard, depending on which standard is relevant to the application type. So this does mean that an additional application needs to be made to obtain that document from UK NARIC, and that must be obviously obtained for submission with the application. So moving on to visitors, the immigration rules have now been clarified to confirm that where visitors have completed the relevant re-entry ban, they can now apply for under the immigration rules to be granted entry and won't automatically be refused leave to remain as a visitor. Another really key change here that will likely affect applicants and employers generally is that the Home Office have now effectively abolished the 28-day overstaying period that used to be allowed and permitted for anybody applying later than their visa expiry date, so where they're applying out of time. Instead, the new policy will be that any out-of-time applications, although they will accept them if it's within 14 days of the expiry of the visa, they do insist that there must be a good reason, which is beyond the control of the applicant or the representative. So this means that an application submitted out of time, so after the expiry date of the visa, won't automatically simply be accepted, as used to be the case, even if it's submitted within 14 days of the expiry. So this clearly means that going forward, applicants and their employers need to be aware of any expiry dates and ensure that any application is submitted before the visa expires. Otherwise, they will be contravening the new rule. You'll see there we've set out the requirements that the Home Office expect to be met, where they will accept an application within the 14 days. So other general changes. The Home Office do reserve the right to request additional information in support of applications under the Tier 2, and as you may well be aware, there is the genuineness test which applies to all applications. Where the Home Office have requested additional documents, individuals, applicants and sponsors must now provide the information within 10 working days, which is a shorter period than the previous 28 calendar days. So it's important to ensure that requests are actioned as soon as they're received and not left to closer to the expiry of the relevant deadline. It will also be open to the Home Office to consider documents when they're sent later, i.e. after an applicant has already made their application. So this is a helpful change, but it does mean that any documents must be submitted before a decision is made. So if you are submitting additional documents, you must ensure it's submitted as soon as possible and certainly before an application decision has been made. I will now hand over to my colleague Ilda de Sousa to speak about upcoming changes.
Thank you, Moji. In terms of upcoming changes, it was for those of you that have been following the Home Office and all the publications following the MAC recommendations, one of the expected criteria that the Home Office were going to follow was to roll out the immigration health surcharge to applicants applying for entry clearance or leave to remain under the intra-company transfer category. Since the publication of the autumn statement, there doesn't at the moment appear to be any amendment or intention to roll out the immigration health surcharge, but perhaps that might be that they may implement that in the future. But for the moment, it doesn't appear as if it will be rolled out. Likewise, through the Migration Advisory Committee, there was also talk about rolling out the skills levy. Again, the skills levy that we could see no mention has been made of, but that doesn't mean that it won't be rolled out in the future. We've now come to the end of our webinar. Thank you very much for listening. You will find our contact details on the screen. If you have any questions in relation to this webinar, please feel free to contact us at the details shown on the screen. Thank you.